day, Judge. Here are the answers to the questions assigned to me. Section 21 of the ADR Act of 2004 states that an arbitration is commercial if it covers matters arising from all relationships of a commercial nature, whether contractual or not. Relationships of a transaction, any trade transaction for the supply or exchange of goods or services, distribution agreements, construction of works, commercial representation or agency, factoring, leasing, consulting, engineering, licensing, investment, financing, banking, insurance, joint venture, and other forms of industrial or business cooperation. Um, Carriage of goods or passengers by air, sea, rail, or road. Section 23 of the ADR Act of 2004 provides for the confidentiality of the arbitration proceedings. The arbitration proceedings, including the records, evidence, and the arbitral award, shall be considered confidential and shall not be published except 1. With the consent of the parties, or 2. For the limited purpose of disclosing of relevant documents in a case where resort to the court is allowed herein. Provided, however, that the court where the action or an appeal is pending may issue a protective order to prevent or prohibit the disclosure of the documents or information containing secret processes, developments, research, and other information where it is shown that the applicant shall be materially prejudiced by an authorized disclosure thereof. Section 28, Paragraph B of the ADR Act of 2004 states that the following rules on interim or provisional relief shall be observed. Number 1, any party may request that provision relief be granted against the adverse party. 2. Such relief may be granted A. To prevent irreparable loss or injury. B. To provide security for the performance of any obligation. C. To produce or preserve any evidence. Or D. To compel any other appropriate act or omission. Number 3. The order granting provisional relief may be conditioned upon the provision of security or any act or omission specified in the order. Number 4. Interim or provisional relief is requested by written application transmitted by reasonable means to the court or arbitral tribunal as the case may be, and the party against whom the relief is sought, describing in appropriate detail the precise relief, the party against whom the relief is requested, the grounds for the relief, and evidence supporting the request. Number 5, the order shall be binding upon the parties. Number 6, either party may apply with the court for assistance in implementing and enforcing an interim measure ordered by an arbitral tribunal. And number 7, the party who does not comply with the order shall be liable for all damages resulting from non-compliance, including all expenses and reasonable attorney's fees paid in obtaining the order's judicial enforcement. The rules of procedure in international commercial arbitration. The general rule is that the parties in international commercial arbitration are free to determine the rules that will govern their arbitration proceedings. In default, the arbitral tribunal shall apply the United Nations Commission on International Trade Law arbitration rules adopted by the UN CITRAL on April 28, 1976, unless the tribunal finds the said rules inappropriate. The procedure for the international commercial arbitration in default of agreement of the parties are as follows. 1. Statement of claims. The or within the period agreed upon by the parties, the claimant shall state the facts supporting his claim, the issues, and the remedy or relief sought, and shall submit and refer the relevant documents. And 2. Statement of defenses. The respondent shall state his defenses. 3. Default of the parties. The failure of the claimant or the respondent to communicate their statement of claims or defenses within the period, or their failure to appear at a hearing or to produce documentary evidence will result in the default of the failing party. The default of the claimant for failure to communicate his statement of claims will terminate the proceedings. But the default of the respondent for failure to communicate his statement of defenses will not terminate the proceedings and shall proceed without such failure being considered as an admission to the allegants to the claimant's allegation. Number 4, amendment of claims and defenses. Parties may amend or supplement their statement of claims or defenses unless the tribunal finds the amendments inappropriate. Number 5, hearings. The tribunal may determine whether to hold oral hearings only or oral arguments only, or just to require the submission of the documents during the appropriate stages in arbitration proceedings. The tribunal or any party with the approval of the tribunal may also request or may seek assistance from the court to take some evidence. The tribunal also has the power to issue subpoena in order to compel the attendance of the witnesses and or the production of the evidence. However, the tribunal does not have contempt powers. The tribunal may also appoint experts and require them to report on specific issues. And the tribunal can also require the parties to provide the experts with access to relevant information or access to documents. The experts appointed by the tribunal is similar to amicus curiae or friends of court. But the difference is these experts field of specialization is not limited to law. Number 6, conclusion or closure. An international commercial arbitration may be concluded or closed in either of two ways, um, by settlement or award, or by termination. The tribunal may issue an order of termination when the claimant withdraws his claim unless the respondent objects on the ground or on the basis of legitimate interest in obtaining a final settlement. A termination order may also be issued when both or the parties agreed to terminate the proceedings in writing, or when the tribunal deems that that the continuation of the proceedings shall become unnecessary and impossible. In both instances, in the settlement of award and the termination, the mandate of the tribunal ends, except when the conclusion of the proceedings is through settlement or an award. Then the mandate of the tribunal extends to correct and implement the award, or to set aside an exclusive recourse against the arbitral award, or when reserved, the quantification of costs and the determination of the party liable, or the division. The jurisdiction or the arbitral tribunal retains jurisdiction unless the award becomes final and executory. Section 34 of the ADR Act of 2004 states that the arbitration of construction disputes shall be governed by Executive Order Number 1008, or otherwise known as the Construction Industry Arbitration Law. Section 4 of EO 1008 provides the jurisdiction of SIAC, or the Construction Industry Arbitration Commission. The SIAC shall have original and exclusive jurisdiction over disputes arising from or connected with contracts entered into by parties involved in construction in the Philippines, whether the disputes arise before or after the completion of the contract, or after the abandonment or breach thereof. These disputes may involve government or private contracts. For the board to acquire jurisdiction, the parties to a dispute must agree to submit the same to voluntary arbitration. The jurisdiction of SIAC may include, but is not limited to, violation of specifications for materials and workmanship, violation of the terms of agreement, interpretation and or application of contractual provisions, amount of damages and penalties, commencement time and delays, maintenance and defects, payment default of the employer or contractor, and change in contract costs. Excluded in the coverage of this law are disputes arising from employer and employee relationship, which shall continue to be covered by the Labor Code of the Philippines. There are 7 classification of forms of ADR. Number 1, as to the number of parties, it can be bilateral or biparty, or multilateral or multi-party. Number 2, as to the number of issues involved, it can be simple or complex. Simple if it only involves one issue, or complex if it involves 2 or more issues. Number 3, as to the extent of conclusion, it can be complete or partial. If it is complete if all the issues were resolved, and it is only partial if one or some issues are resolved. Number 4, as to the role of evidence in the proceedings, it can be evidentiary or merit-based, or non-evidentiary or non-merit-based. So evidentiary or merit-based happens when the resolution of the dispute requires the presentation of evidence and the evaluation of the merits of the case. It is non-evidentiary or non-merit-based if the merits of the case is not indispensable for the resolution of the case, as in the case of mediation. Number 5, as to the pendency of a court case, it can either be case-related or independent. So ADR is case-related if it is conducted in connection or as a prerequisite to a trial, as in the case of court-annexed mediation or court-referred mediation. It is independent if it is conducted irrespective of any pending court case involving the issue. Next is the as to the applicable. Number 6 is as to the applicable law. So it can either be domestic or international. Domestic if the party's place of business, place of arbitration, the place of the performance of the obligation involved, or the subject matter arising from the dispute is in the Philippines. Or international if the party's place of business are in different states and the place of arbitration is outside the Philippines. And number 7, as to the permanence of the ADR provider. It can be either ad hoc or institutional. Either ad hoc is when the existence of the ADR provider is only temporary for the resolution of a particular dispute. It is institutional if the existence of the ADR provider is permanent in nature, regardless of whatever the issue or the dispute is. Licomken Incorporated versus Foundation Specialist Inc. Or the FSI. Facts of the case are as follows. Licomken is a domestic corporation engaged in the business of operating malls. The government of Legazpi awarded a lease contract to Licomken in its central business district. Licomken will finance the construction of LCC Mall and will operate the same for 50 years. Licomken then hired E.S. De Castro and Associates as its engineering consultant and also hired Foundation Specialist Inc. or the FSI to do the initial construction works. On September 1, 1997, Licomken and FSI signed a construction agreement and the general conditions contract. Thereafter, FSI procured materials and began working in order to meet the 90-day deadline of Licomken. However, on December 16, 1997, Licomken informed FSI that it is considering major design revisions, and it also told them that the construction works will be suspended. The FSI then expressed their concern over the construction revisions, as they have ordered the steel bars for this project. ESCA then informed FSI to deliver only 50% of the steel bars, but the FSI delivered all of the steel bars. Also, FSI was informed by Licomken that all construction works will be suspended because there is a pending ombudsman case. FSI then asked for payment from Licomken for all the construction works and materials in the amount of 22.7 million. Since Licomken failed to pay FSI, the FSI filed a petition for arbitration before the SIAC, or the Construction Industry Arbitration Commission. However, Licomken questioned the jurisdiction of SIAC as the subject matter should have been raised before the courts of Legazpi City. The SIAC denied the motion of Licomken and instead ruled in favor of FSI. The Licomken appealed the decision, and the CA, or the Court of Appeals, affirmed the decision but ordered to reduce the awards to be given to FSI. Hence, both parties appealed via petition for certiorari before the Supreme Court. So the issues of the case are: 1. Whether or not SIAC has jurisdiction over the dispute. 2. Whether or not the damages be reduced. And 3. Whether or not Licomken should bear the cost of arbitration. So the ruling of the court: first, on the issue of SIAC jurisdiction, the court said that SIAC has jurisdiction over the subject matter. So SIAC was instituted by passing Executive Order number 1008, as the government needed to install, or needed to create, an arbitral machinery to expedite the settlement of construction industry disputes. So the party signed the GCC, and part of the GCC stated that in case problems or issues will arise between FSI and Licomken, those issues should be questioned before the courts of Legazpi City. But there is an exception stated in the GCC. It says that except when the parties agree to settle the issue through arbitration. So the court said that clearly that clause, that exception clause, authorizes the jurisdiction of SIAC in order to resolve this construction dispute. Second, whether or not the awards may be reduced, the court said that yes, it was proper for the CA to reduce the damages to be awarded to FSI. The court said that ESCA already informed FSI not to deliver all of the steel bars, but only half of it, only 50%. It was shown in the records that the FSI acted imprudently, and although there was a way not to deliver all of the steel bars, they still proceeded and delivered all of the steel bars and charged it to Licomken. Therefore, the court held that since there was bad faith on the part of FSI, the awards, or the 50% of the steel bars, will be borne by the cost of the 50% of steel bars will be borne by FSI. And lastly, the issue of whether or not Licomken should bear the cost of arbitration. Yes, the court ruled that SIAC was correct to order Licomken to bear the cost of arbitration. It was held that the proximate cause of the issue is Licom Ken's suspension of construction works. And since it was Licom Ken's acting imprudently that caused the dispute, it is but proper to for them to shoulder the cost of arbitration. Although in the agreement in the GCC, both parties agreed that half the cost of arbitration will be borne by both parties.